In a constitutional democracy like India, the balance between legislative authority and judicial oversight is, well, pretty delicate. A key question emerged in 2011. Can a state enact a law that appears to countermand a Supreme Court order? This legal puzzle unfolded dramatically in the case of Nandini Sundar versus State of Chhattisgarh. In July 2011, the Supreme Court ordered Chhattisgarh to stop using special police officers, or SPOs, in anti-Naxalite operations. The court held that arming inadequately trained tribal youth violated their rights under Articles 14 and 21. It mandated that all firearms be withdrawn and no state or union funds be used to support such operations. The judgment was a constitutional landmark. The court stated that recruitment and arming of SPOs to engage Maoists was unconstitutional, disproportionately targeting vulnerable communities. It also barred the center from funding such forces, reinforcing the principles of dignity, equality, and procedural fairness. Just months later, the state legislature passed the Chhattisgarh Auxiliary Armed Police Forces Act 2011. It authorized the creation of an auxiliary force to assist security forces in maintaining public order. Critics called it a legislative workaround to defy the court's verdict. So, a contempt petition was filed. The petitioners argued that the act basically revived the disbanded SPO system just under a new name, which, in their view, defied the court's directive. The central issue here was, does passing a new law that looks a lot like a banned policy actually amount to contempt of the Supreme Court? The court, however, dismissed the contempt plea. It held that, while its orders are definitely binding on the executive, legislatures actually enjoy plenary power. Unless the new act was shown to be unconstitutional, it just couldn't be held in contempt. This interpretation, really reaffirmed the separation of powers. The Supreme Court clarified that any law, even if it's super similar to a previously struck down policy, can't be invalidated on grounds of contempt. Instead, it must be challenged on two prongs: legislative competence and constitutional validity. Basically, whether it violates the Constitution or steps into another tier of governance. In Indian Aluminium Co. versus Kerala, the court held that legislative actions cannot be curtailed by mere judicial dissatisfaction. Unless a statute violates the Constitution or fundamental rights, courts must refrain from interference. This case, honestly, just reinforced that position. Public order is a state subject. But when it intersects with internal security and counter-insurgency, as in Naxal areas, a collaborative federal approach is essential. The court's 2011 order tried to harmonize security imperatives with constitutional morality, putting rights before retaliation. Even if the 2011 Act was technically valid, was it ethically defensible? Should legislatures bypass judicial reasoning by relabeling? The court may have exercised restraint, but honestly, the episode raises deeper questions about constitutional morality and fidelity to justice. Yes, but only when a law violates the Constitution. Article 13 empowers courts to strike down any law inconsistent with fundamental rights. But courts cannot strike laws merely for defying past judgments. Judicial review is robust, but it respects legislative autonomy. The Nandini Sundar case teaches that governance requires dialogue among institutions. The judiciary can enforce, the legislature can legislate, but both must act in the spirit of the Constitution. In the final analysis, democracy thrives not just on powers, but on principles.